Ladies and gentlemen, Adam Schiff said the word evidence, and Mike Johnson was ready with the exact response that turned a routine hearing into a moment of lasting clarity for the entire country. Good evening. I am speaking to you tonight as both a longtime public servant and the host of this program because what unfolded in that hearing room demands careful attention from every citizen who values honest language in our public life. The session was officially about intelligence community reform, yet within the first minutes it became something far more revealing. Adam Schiff arrived with the familiar posture of a former federal prosecutor who has spent years treating every appearance as an opportunity to set the frame. His jaw was set, his briefing materials held close, and his opening remarks followed a well-practiced pattern. He dismissed the stated purpose of the hearing, referenced his earlier censure, and then turned directly toward Speaker Mike Johnson with a polished attack. Schiff argued that the real irony lay in allowing a man who had voted to challenge the 2020 election results to preside over any discussion of institutional integrity. The language was sharp, ready for cable packages and fundraising appeals, and the room reacted exactly as Schiff seemed to expect. Johnson did not take the bait. He did not defend his own record or chase Schiff into a sprawling argument about January the 6th. Instead, he adjusted his glasses, opened a binder, and focused on a single word that Schiff had just used without hesitation. That word was evidence. Johnson noted that both men are lawyers who attended law school and therefore understand that evidence carries a precise meaning in the legal profession. It is not simply a dramatic term for suspicion or a useful phrase in a campaign email. Johnson asked whether Schiff had been using the word the way lawyers use it or the way fundraisers use it. The temperature in the room changed immediately because the confrontation had been narrowed from personality and party to vocabulary and professional standards. Johnson then began placing Schiff's public declarations beside the official record with methodical patience. On March 22nd of 2017, Schiff appeared on CNN and stated that the evidence was not merely circumstantial, but direct. On February 14th of 2018, he told an MSNBC audience that ample evidence concerning collusion was already available in the public domain. On April 7th of 2019, he informed ABC News that evidence of collusion was in plain sight. These were not cautious statements about ongoing inquiries or possible leads. They were declarations of certainty delivered by a former prosecutor who chaired the House Intelligence Committee and therefore possessed access to classified material unavailable to ordinary viewers. Johnson set those statements next to the findings that followed. The Mueller report released on April 18th of 2019 did not establish that members of the Trump campaign conspired or coordinated with the Russian government. The December 2019 report from Inspector General Michael Horowitz identified at least 17 significant errors or omissions in the FISA application process. In May of 2023, Special Counsel John Durham concluded that the Federal Bureau of Investigation had failed to uphold its obligation of strict fidelity to the law, and that the investigation had been opened on the ladies and gentlemen. Adam Schiff said the word evidence, and Mike Johnson was ready with the exact response that turned a routine hearing into a moment of lasting clarity for the entire country. Good evening. I am speaking to you tonight as both a longtime public servant and the host of this program because what unfolded in that hearing room demands careful attention from every citizen who values honest language in our public life. The session was officially about intelligence community reform, yet within the first minutes it became something far more revealing. Adam Schiff arrived with the familiar posture of a former federal prosecutor who has spent years treating every appearance as an opportunity to set the frame. His jaw was set, his briefing materials held close, and his opening remarks followed a well-practiced pattern. He dismissed the stated purpose of the hearing, referenced his earlier censure, and then turned directly toward Speaker Mike Johnson with a polished attack. Schiff argued that the real irony lay in allowing a man who had voted to challenge the 2020 election results to preside over any discussion of institutional integrity. The language was sharp, ready for cable packages and fundraising appeals, and the room reacted exactly as Schiff seemed to expect. Johnson did not take the bait. He did not defend his own record or chase Schiff into a sprawling argument about January the 6th. Instead, he adjusted his glasses, opened a binder, and focused on a single word that Schiff had just used without hesitation. That word was evidence. Johnson noted that both men are lawyers who attended law school and therefore understand that evidence carries a precise meaning in the legal profession. It is not simply a dramatic term for suspicion or a useful phrase in a campaign email. Johnson asked whether Schiff had been using the word the way lawyers use it or the way fundraisers use it. The temperature in the room changed immediately because the confrontation had been narrowed from personality and party to vocabulary and professional standards. Johnson then began placing Schiff's public declarations beside the official record with methodical patience. On March 22nd of 2017, Schiff appeared on CNN and stated that the evidence was not merely circumstantial, but direct. On February 14th of 2018, he told an MSNBC audience that ample evidence concerning collusion was already available in the public domain. On April 7th of 2019, he informed ABC News that evidence of collusion was in plain sight. These were not cautious statements about ongoing inquiries or possible leads. They were declarations of certainty delivered by a former prosecutor who chaired the House Intelligence Committee and therefore possessed access to classified material unavailable to ordinary viewers. Johnson set those statements next to the findings that followed. The Mueller report released on April 18th of 2019 did not establish that members of the Trump campaign conspired or coordinated with the Russian government. The December 2019 report from Inspector General Michael Horowitz identified at least 17 significant errors or omissions in the FISA application process. In May of 2023, Special Counsel John Durham concluded that the Federal Bureau of Investigation had failed to uphold its obligation of strict fidelity to the law and that the investigation had been opened on the basis of raw, unanalyzed, and uncorroborated intelligence. 3 sets of confident public declarations stood beside 3 major investigative conclusions that described a far weaker and less conclusive record. Schiff responded by attempting to broaden the discussion, challenge the credibility of the Durham findings, and redirect attention toward contacts documented in the Mueller investigation. Johnson refused the escape route and returned to the definition. He asked again whether Schiff had used the term evidence in its legal sense. A yes or no answer carried risk either way. Admitting loose usage would concede recklessness. Insisting on legal precision would require defending certainty that the official findings did not support. Schiff began to answer, stopped, and tried again, experiencing the narrowing pressure he had long applied to witnesses. The prosecutor, who had controlled questions for years, found himself trapped inside one, not because of raised voices, but because the disputed word could not be replaced by a safer argument. Johnson reinforced the point by reminding the room that a former federal prosecutor knows exactly how carefully evidentiary language must be handled when reputation and public trust are at stake. Direct evidence is not a synonym for suspicion. Evidence in plain sight is not interchangeable with the belief that investigators might someday confirm a theory. Schiff had chosen declarations rather than qualifications in prosecutorial authority, rather than ordinary opinion while speaking to an audience unable to inspect the classified material behind the claims. The issue was no longer whether reasonable people could disagree about contacts or the political meaning of the Mueller investigation. The issue was whether a man with privileged access had used the authority of that access to lead the public to believe that something had been legally established when the investigations themselves never established it. At this stage, Johnson turned the page in his binder and shifted from the meaning of the word to the financial record attached to it. He introduced Brenda Holloway, a retired postal worker from Bakersfield, California, who spent 31 years carrying mail before retiring in 2020 on a pension of roughly $2,800 a month. Brenda watched the television appearances, trusted the repeated claims, and began donating $25 every month because she believed a former federal prosecutor with classified access was describing something real, Over 8 years, those modest contributions totaled $2,400, a serious sum for a retiree living on a fixed income whose only information came from what elected officials said on television. Schiff possessed the briefings, Brenda possessed the television set. The entire transaction rested on her belief that the man with privileged information was using the word evidence honestly. Johnson then opened the campaign filings and read the numbers without theatrical emphasis. In 2018, during the height of the television campaign about direct evidence and collusion, the operation raised approximately $14.3 million. In 2019, the year the Mueller report failed to establish a conspiracy, the total was another $12.7 million. In 2020, after the investigation had closed and the central promise of decisive proof had weakened, the fundraising total rose to roughly $16.4 million. The word did not lose financial value when the underlying case failed to produce the advertised result. By then, evidence had become the centerpiece of a highly effective political brand. The structure required only that viewers continue to believe Schiff possessed something they had not yet seen. Every television appearance extended the sense of urgency. Every claim of hidden knowledge protected the brand. Every criticism created another reason for an urgent appeal. Johnson moved next to the 2023 censure vote. During the vote itself, Schiff's campaign sent an email warning that false and defamatory claims were being spread and urging supporters to donate immediately. That quarter produced approximately $8.2 million, the strongest fundraising quarter of the career. Official condemnation had been converted into revenue before the chamber finished processing the accusation. Johnson connected the number back to Brenda. Without donors like her, the $8.2 million remains an abstract figure. She sent $25 because she believed evidence existed. She was asked to send more when the claims were challenged. The supposed proof generated contributions. The lack of confirmation generated a sense of persecution. The sense of persecution generated still more contributions. Johnson's tone shifted from patient explanation to legal analysis. He noted that Schiff possessed classified intelligence, publicly described evidence in terms stronger than the record supported, and used the authority created by that access while soliciting contributions from millions of Americans. He identified the familiar elements associated with federal wire fraud statutes, a scheme, a material misrepresentation, the use of wire communications, and an intent to obtain money. Television broadcasts carried the claims. Electronic messages delivered the solicitations. Campaign accounts received the funds. Johnson did not declare guilt. He simply observed that a former Federal Election Commission official had reviewed a related complaint and publicly concluded that the matter contained enough material to justify a civil inquiry and serious consideration by the Department of Justice. The observation moved the discussion out of pure partisan exchange and into the language of formal review. The arithmetic was straightforward. The American public spent roughly $32 million on the Mueller investigation, while approximately $80 million were raised discussing the evidence that investigation was expected to validate. $32 million were spent searching, $80 million were raised by declaring that the proof already existed. Johnson returned to Brenda because the hearing was no longer about media habits alone, but about the trust transferred from ordinary citizens to a public official presenting himself as a guardian of legal accuracy. Brenda gave $2,400 because she believed prosecutors use words carefully and because a person who once placed defendants in prison should understand the consequences of presenting suspicion as proof. Her contribution rested on faith in professional credibility, and that credibility had been the asset most aggressively converted into revenue. Schiff fought back by reframing the entire matter as a disagreement over the interpretation and weight of intelligence rather than a misrepresentation made for financial gain. He argued that assessments can differ, that reasonable officials can examine the same information and reach different conclusions, and that the proceeding was attempting to criminalize political judgment. The word assessment introduced uncertainty and therefore space to retreat from absolute language. Johnson had prepared for that move. He reminded the room that Schiff had not publicly said his assessment suggested evidence might exist. Schiff had said the evidence was direct, ample, and in plain sight. Those declarations are not the cautious language of professional judgment. They are the language of certainty. Johnson explained the distinction with precision. An assessment is what a professional offers when facts remain incomplete and reasonable people may differ. A doctor may assess that a patient has pneumonia before every test is finished. An investigator may assess that a contact deserves closer scrutiny. Schiff, however, did not spend years telling audiences that his assessment suggested direct evidence might exist somewhere in the files. He declared that the evidence was already direct, ample, and visible. The transcripts contain no qualifications, such as perhaps in my preliminary view or based on incomplete information. There is only the authority of a former prosecutor, the position of an intelligence chairman, and repeated declarations that direct evidence already existed. Schiff was not trapped by Johnson's wording. He was trapped by his own. That is why the word assessment failed as an escape and instead became another point against the credibility of the explanation. A genuine assessment leaves room for revision when additional facts emerge. Schiff's public posture did not soften after the Mueller report failed to establish conspiracy. He did not return to the cameras and acknowledge that earlier certainty had exceeded what the investigation could prove. He did not explain to contributors that the language of direct evidence had been stronger than the final record justified. The fundraising operation continued. Accusations evolved. Challenges to credibility were transformed into further appeals for support. The correction never arrived because a correction would have damaged the product. Johnson then opened the final section of the binder. A large screen displayed a chart with two lines that required almost no explanation. The blue line represented the number of television appearances in which Schiff used the word evidence. The red line represented fundraising receipts during the same periods. The lines rose together, fell together, and peaked together with a correlation so tight that one appeared to be the shadow of the other. When appearances increased and the language about evidence grew more aggressive, donations increased. When television frequency declined, fundraising totals declined with it. Johnson was careful to describe the chart as correlation rather than causation, a distinction Schiff himself should appreciate after years of presenting correlations as grounds for sweeping inquiries. Yet the visual was powerful precisely because the audience did not need to be told what conclusion to reach. Millions of people can look at two synchronized lines and understand that the media appearances and the contributions were not operating in separate universes. Johnson brought Brenda Holloway back into the center of the argument. She watched the appearances represented by the blue line, believed the claims made during those appearances, and contributed the money represented by the red line. Multiply her modest monthly payment by millions of donors, and the result is an enormous revenue stream built around a repeated promise of certainty. Schiff could not offer those donors the classified material. He could not allow them to test his interpretation. He could not provide the direct evidence he said was already in plain sight. He could only offer his credibility, and that credibility had been priced at approximately $80 million. Johnson closed the binder, removed his glasses, and placed them on the documents. He returned to Schiff's opening attack about evidence, oaths, accountability, and the supposed irony of Mike Johnson presiding over the hearing. Johnson agreed that irony was present, but not in the location Schiff had identified. The irony was that a politician who spent years insisting that nobody stands above the law now asked that his own language be treated as flexible, harmless, and immune from the standards he imposed on everyone else. Schiff had demanded exactness from witnesses, officials, investigators, and political opponents, yet now sought the softest possible interpretation of his own words. The word was evidence. The evidence never appeared in the form promised. The money generated by the promise was unquestionably real. Brenda Holloway's $25 arrived every month. Campaign deposits accumulated. Fundraising totals rose while the underlying claim became weaker under official scrutiny. Supporters were not funding a proven case. They were purchasing continued access to a narrative whose permanent incompleteness kept it profitable. Once the product was exposed as a promise rather than proof, the operation no longer looked like public service alone. It looked like a sophisticated transaction in which ordinary people paid for certainty and received slogans. The chairman asked whether Schiff wished to make a closing statement. Schiff responded with 2 polished minutes about the rule of law, democratic institutions, government oversight, and the courage required to confront powerful interests. He spoke with the same practiced cadence that had carried him through years of appearances, but he avoided the numbers that had just been placed in front of him. He did not mention the $80 million, the fundraising message sent during the censure vote, the chart showing synchronized appearances and donation spikes, or Brenda Holloway's retirement income. He returned to the language of principle because principle is safer than arithmetic. For the first time, the language sounded less like conviction and more like packaging. Johnson did not interrupt or attempt a final dramatic exchange. The record had already done the work. He straightened the binder, placed his pen beside it, and glanced toward the clock as the 43-minute hearing approached its conclusion. In less than an hour, the word evidence had been stripped of its protective political meaning and returned to the legal definition Schiff once relied upon as a prosecutor. The confrontation did not turn on volume or personal insult. It turned on transcripts, investigative findings, fundraising records, and a chart 2 colors wide. Outside the hearing room, the most consequential phase was only beginning. The chart clip spread because viewers did not need a legal education or a classified briefing to understand what synchronized lines mean. Every rise in televised certainty was followed by a rise in political revenue. Every decline in media exposure was matched by a decline in fundraising momentum. Within 72 hours, the chart reached approximately 26 million views. It became more powerful than any verbal attack because it did not ask the audience to trust one interpretation. The blue line represented the public performance. The red line represented the cash. The movement between them exposed the commercial rhythm behind the rhetoric. A second clip focusing on the attempt to retreat from certainty into the safer language of assessment reached roughly 17 million views. Legal professionals circulated it because the distinction is not cosmetic. Anyone who has drafted a brief or examined a witness understands the difference between suspicion and direct evidence. The defense failed not because political assessments are forbidden, but because absolute statements were being rewritten as cautious professional opinions after the underlying certainty became impossible to defend. Former prosecutors, defense attorneys, and law professors began debating the exchange. The most damaging reactions came from people who understand how carefully evidentiary language is supposed to be used. One former United States attorney observed that a line prosecutor who described evidence as direct when the file did not support that description would face immediate professional consequences. Others noted that political television is not a courtroom, yet Schiff had deliberately borrowed courtroom authority while speaking to viewers who could not review the classified record. He wanted the credibility of the prosecutor without accepting the discipline imposed on prosecutors when claims exceed available proof. The hearing forced that contradiction into the open, and status as a former prosecutor became an aggravating fact rather than a shield. During the first week after the hearing, Schiff's office released a statement calling the proceeding a partisan exercise in revisionist history. The statement defended the interpretation of intelligence available at the time and emphasized that political speech remains protected under the First Amendment. Legally, the defense was predictable. Politically, the First Amendment response sounded less like a defense of accuracy and more like an argument that saying misleading things on television is constitutionally permitted. Protected speech and honest speech are not identical. The hearing was never primarily about whether the words could be said. It was about whether the words were accurate when they were sold to donors. Campaign finance watchdogs from different political backgrounds submitted requests asking the Federal Election Commission to examine the relationship between the television appearances and the fundraising solicitations. Their requests cited the chart, the timing of the campaign messages, and the repeated use of claims about evidence to create urgency among donors. The commission had previously dismissed a similar complaint in 2022 after a 3-3 deadlock, but the renewed attention meant the issue could no longer be buried as an obscure technical dispute. The question became whether fundraising messages contained material representations inconsistent with the information possessed through classified briefings. Even without a formal finding, the existence of review requests forced the campaign to confront the one subject the closing statement had avoided completely: the money. In the second week, a nonpartisan government accountability entity submitted a request to the Senate Ethics Committee for a preliminary review of the fundraising practices. The referral did not accuse anyone of a crime and did not claim that a violation had already been established. It asked whether communications with donors were consistent with the intelligence available at the time. That narrow wording is dangerous because it removes emotional language and focuses on a document comparison that cannot be easily dismissed. What did the briefing show? What was said publicly? What did the fundraising messages imply to the people being asked for money? A partisan attack can be answered with another partisan attack. A records-based ethics request forces a response grounded in dates, language, and evidence. Legal analysts remain cautious about references to wire fraud. Most agreed that proving criminal intent in a political speech case would be extraordinarily difficult. One could argue genuine belief in the characterization of the intelligence, that political rhetoric is inherently broad, and that donors contributed for many reasons beyond statements about Russia. Yet difficult does not mean imaginary. The elements described are recognizable enough to make the question credible, and the fundraising totals are large enough to ensure the issue cannot be dismissed as a minor campaign misunderstanding. There may never be a criminal charge, but the public has been shown a structure in which privileged information, absolute public claims, electronic solicitations, and $80 million occupy the same record. The most human development arrived in the third week when Brenda Holloway appeared on a Bakersfield television station from the kitchen where she had watched the interviews and made her monthly donations. A magnet reading "Truth Matters" was visible on the refrigerator behind her, the kind of inexpensive item sent to small donors as a symbol of appreciation. Brenda explained that she gave $25 every month because Schiff repeatedly said he had evidence and because she assumed a former prosecutor with classified access would not use that word casually. She admitted that she continued to believe even after the investigations failed to validate the certainty because she trusted the messenger more than she trusted the official conclusions. Then she said the sentence "no campaign statement can neutralize." He was not right, and she cannot get her money back. The interview reached approximately 5 million views because Brenda is not a political celebrity or a professional commentator. She is an ordinary retired worker who gave away part of a modest pension because she believed a powerful official possessed proof that ordinary citizens could not see. Millions of small donors recognized themselves in her frustration, not because they all contributed the same amount or shared every political belief, but because they understand the disappointment of paying for certainty that never arrives. The operation had always treated small donors as statistics, proving grassroots enthusiasm. Brenda's interview gave one of those statistics a face, a fixed income, and a quiet demand for accountability. The $80 million no longer looked like a pure campaign achievement when viewers were forced to consider how many $25 sacrifices were required to build it. The word evidence has not vanished from the vocabulary, and the fundraising machinery has not permanently shut down simply because one hearing exposed its rhythm on live television. Political systems built over years rarely collapse after a single confrontation, especially when strong emotions and partisan loyalty remain effective. Yet the word no longer lands with the same unquestioned authority. Millions of viewers have seen the chart, heard the distinction between assessment and declaration, and watched Brenda explain what her trust cost. Every future use now carries the shadow of the binder, the synchronized lines, the censure message, and the $80 million total. Johnson did not merely challenge a story. He changed what the audience hears whenever that story is told again. That is the lasting consequence, and it is far more enduring than any temporary victory in a committee room. Adam Schiff spent years presenting himself as the official who possessed facts others were too frightened or compromised to acknowledge. Mike Johnson forced the public to examine the possibility that the most valuable political asset was not the evidence itself, but the impression that evidence existed somewhere beyond public reach. The American people spent $32 million searching for the proof, while $80 million were raised by repeatedly declaring that the proof was already visible. The evidence was never the product. The word was the product, and millions of Americans paid for it before anyone opened the binder and showed them the receipt.